We also provide a full range of forensic fraud investigation services, and we also provide technology advisory services. Within those headings, we provide data privacy services. We also provide ESG sustainability services and a host of other services. Let me just take you back to our data privacy journey thus far. We've had 4 data privacy webinars before this. We started part 1 with the registration guides, and then we went on to key roles in data privacy. We gave you some tips on the compliance journey, and we went through the data protection laws in East Africa. And today we're going to talk about tips to avoid complaints from regulatory bodies. We started in July. We've had a webinar every month, and this is our last webinar for this year, but we're going to be back with a lot more webinars. So just watch this space. We're active, very active in training, and we want to be interacting with you on a monthly basis on the various things that are topical. These are the topics that we've covered thus far. You can see we've come very far. We talked about registration requirements under the various data protection legislations in all of our East African countries, including Mauritius. We gave you advice on how to register. We went through the registration forms. We talked about the deadlines and the timeframes for registration, the validity of registration, how to cancel registration. We talked about the description of the roles of the controller, the processor, the sub-processor, and the data collector, as well as third parties, as well as the relationship between those 2 roles. We talked about their obligations and also about the agreements between the controller and the processor. We then talked about how to conduct a data inventory and data mapping exercise and to do a gap analysis on data. We then talked about the data, developing a privacy framework in terms of drafting policies and procedures and contracts, and also in terms of the implementation. And we gave you lots of examples, particularly from HR and finance, on policies and procedures. We've compared the laws in the GDPR, which is the law for EU, as well as the laws which are applicable in East Africa. We've also told you what sort of training your staff need, how to protect personal data, how to respond to data subject access requests on time. We've talked to some length about transparency in the collection and use of personal data, CCTV and video surveillance limits, collecting only data. We've talked about the principles of data collection as well, and how to be proactive, and in terms of hiring a data protection officer. So somebody asked us about where the other data privacy webinars are. Well, this is where they are. If you go to YouTube in the search bar and you type BDO East Africa, you will see all of the webinars that we've done. And recently we've done about 17 webinars. You'll see 14 of them. This one's going to be uploaded as soon as we finish. And the link is basically there. It's youtube.com/@BDO in East Africa. And there you will have all of our webinars. We've done webinars, not just in data privacy, but we've done webinars in forensic, fraud management services. There's 4 webinars there. You'll find 5 webinars on internal audit. You'll find a host of webinars on transfer pricing. And all of these webinars are about 1 hour. The forensic webinars went on to about 1.5 to 2 hours, but there's a lot of very useful stuff there. So our agenda for today, after the introduction, I'm going to look at a consumer privacy survey that's just been released last month by Cisco. We're then going to look at a case. We're going to do a case study which looks at the consequences for data security breaches and how serious those can be. We went through local sanctions, but I'm going to do a quick recap because I know this one is specifically for CEOs, C-level people, and data, as well as directors. So I'm hoping that we've got some C-level executives with us today. And for your benefit, I'm going to do a recap on the local sanctions with an example from Kenya. We'll then look at the key questions that an organization's board of directors must ask in relation to data privacy. We're also going to give you tips for avoiding complaints from the Office of the Data Protection Commissioner. And finally, we'll conclude with some questions and answers. So going on to the Consumer Privacy Survey, this is a survey that's been released by Cisco in October 2022. And the question is, how do organizations earn and build trust when it comes to the personal data that customers share with them? Customers certainly expect these organizations to comply with all privacy laws that are now in place in more than 130 countries. Customers also expect organizations not to sell personal data without their consent and to try to avoid data breaches that could expose their personal data. While these actions are necessary by organizations, we believe organizations can do much more when it comes to building and retaining customer trust. According to Cisco's latest research, consumers' top priority is, in fact, for organizations to be more transparent about how they use personal data. The Cisco 2020 Consumer Privacy Survey, which was released on the 11th of October 2022, explores what organizations can do to earn and build trust with their customers, the actions that individuals are taking to protect their data, the impact of privacy laws around the world, and some of the benefits and costs of artificial intelligence and data localization requirements. This infographic here looks at the top consumer need from organizations handling their data. Consumers chose data transparency as the top thing that organizations can do to build trust regarding how personal data is used and protected. 39% data transparency was selected, almost twice as much as refrain from selling personal information at 21%, or complying with all privacy laws at 20%. The most important activity that organizations can do to build trust with customers regarding their data is to provide clear information about how the data is being used. In this infographic, we look at how customers want transparency and control. 43% of customers are not confident that they can adequately protect their personal data. I mean, that's a big number, that's nearly half. And of that number, 79% don't know what companies are doing with their personal data. 51% said that they have to accept how a company uses their data if they want the service. So basically, you know, they've got a gun held to their head. And 46% believe that their personal data is already available to companies regardless. So that's pretty concerning. This graphic shows the response of survey participants for the privacy laws in their countries. The upper green part of the circle indicates whether the participants believe that the data privacy laws have a positive impact to protect their interests. While the dark blue part at the bottom, that shows those participants that feel that the data privacy laws may have a negative impact on their personal privacy. As you can see from the infographic, consumers continue to strongly support their nation's privacy laws, as they want their government to take a leading role in protecting personal privacy. On average, 61% of the respondents felt that these laws are having a positive impact, whereas only 3% believe they are having a negative impact. Awareness of these laws continues to be a challenge, as only 43% of respondents say they are actually aware of what their country's privacy laws are. So as awareness by data subjects increases, so is the action that we expect them to take to protect their data. This infographic shows the support and concerns of survey participants with organizations using personal data in artificial intelligence. When it comes to applying and using artificial intelligence, consumers are supportive, but very concerned with today's practices. Whilst 43% say that artificial intelligence can be useful in improving our lives, and 54% are even willing to share their anonymized personal data to improve artificial intelligence products, 60% of respondents are concerned about how businesses are using artificial intelligence today. In fact, 65% say they have already lost trust in organizations due to their artificial intelligence practices. This infographic here shows the survey participants' support for data localization or data residency law requirements. Data localization or data residency laws are laws that require data about a nation's citizens or residents to be collected, processed, and or stored inside their country, often before being transferred internationally. Such data should usually be transferred only after meeting local privacy or data protection laws, such as giving the user notice of how the information will be used and obtaining their consent. 78% of survey respondents showed support for data localization requirements. However, if data localization were to add costs to the products and services that consumers buy, then the survey respondents were evenly split on the value of data localization requirements. 41% were in favor and 41% were against. Interestingly, in 9 out of the 12 countries surveyed by Cisco, more respondents were against data localization than in favor. In this graphic here, you can see the consumer privacy behaviors regarding their personal data. 53% manage their cookie preferences, 46% turn off home listening devices regularly to protect their privacy, and 45% use privacy screens to protect their personal data and shield information about them. More consumers are taking action to protect their personal data. 37% in accordance with the survey have stopped using a company or provider over their data practices. 24% have exercised their data subject access rights to inquire about data companies, about the data that companies have about them, and 14% have requested changes or deletions to that data. These numbers are all going to go up in future as data subjects become aware of their rights and the obligations placed upon organizations to protect the personal data. Let's now look at a case study where there's been a data security failure and the consequences of that. The case study is on a company called Drizzly. Drizzly is a US online liquor marketplace or store. The company is based in Boston, US, and it is a subsidiary of Uber. It operates an online marketplace where consumers of legal drinking age can place orders with retailers to buy beer, wine, and alcohol for delivery. The company uses Amazon's cloud computing services to collect and store a wide range of personal information from consumers, such as email, postal addresses, phone numbers, unique device identifiers, geolocation information, and data purchased from third parties. So a little bit about background to this case. If you look at the FTC website on the 24th of October 2022, the Federal Trade Commission is taking action against Drizly and its CEO, James Corey Reles, over allegations that the company's security failures led to a data breach, exposing the personal information of about 2.5 million consumers. Drizly and Reles were alerted to security problems 2 years prior to the breach, yet they failed to take steps to protect consumers' data from hackers. The FTC proposed order, it requires the company to destroy unnecessary data, and it restricts the data that the company can collect and retain. And the order binds its CEO, Reles, to specific data security requirements for his role in presiding over unlawful business practices. So this is what Samuel Levine, director of the FTC's Bureau of Consumer Protection, had to say as regards the order. I mean, he said, our proposed order against Drizly not only restricts what the company can retain and collect going forward, but it also ensures that the CEO faces consequences for the company's carelessness. And he further stated that CEOs who take shortcuts on security should take note. According to the FTC's complaint, Drizly and Reles were alerted to problems with the company's data security procedures following an earlier security incident. In 2018, a Drizly employee posted company cloud computing account login information on the software development and hosting platform GitHub. As a result of this security breakdown, hackers were able to use Drizly's servers to mine cryptocurrency until the company changed its login information for its cloud computing account. Drizly failed to take steps to adequately address its security problems while publicly claiming to have appropriate security protections in place. 2 years later, a hacker breached an employee account, got access to Drizly's corporate GitHub login information, and hacked into the company's database and then stole customers' information. So in its complaint, the FTC alleges that Drizly and Reles a number of things. First of all, that they failed to implement basic security measures. The FTC alleged that despite statements claiming that the company had used appropriate security practices to protect consumer data, Drizly and Reles, in fact, had failed to put in place reasonable safeguards to secure the personal information it collected and stored. So, for example, it did not require employees to use two-factor authentication for GitHub. It also did not limit employees' access to personal data. It did not develop adequate written security policies, and it did not train employees on those procedures. The other thing that the FTC alleges that Drizly and Reles did was it stored critical database information on an unsecured platform. According to the FTC's complaint, Drizzly stored login credentials on GitHub, contrary to the platform's own guidance and well-publicized security incidences involving GitHub. For example, in 2018 complaint against Uber, the FTC specifically publicized and described poor security practices involving the use of Uber's GitHub account that contributed to a data breach involving the ride-sharing app. One of the other allegations was that Drizzly and Relish neglected to monitor network for security threats. The FTC alleged that Drizzly did not put a senior executive in charge of ensuring that the company was keeping its data secure, nor did it monitor its network for unauthorized attempts to access or remove personal data. The next allegation against Drizzly and its CEO were that they exposed customers to hackers and identity thieves. Following the company's data breach, personal information that Drizzly had collected about consumers was offered for sale on 2 different publicly accessible sites on the dark web, where criminals post and sell data stolen by hackers. We talked about the dark web, in fact, in some of my webinars, particularly on the fraud webinars, fraud risk management webinars. And then the identity thieves and other malicious actors can use this data to open fraudulent lines of credit or to commit other fraud. And it is the unsuspecting data subjects that then bear the brunt of the use of this illegally obtained information. Enforcement action taken against Drizzly and its CEO. So the proposed order against Drizzly and Relish includes several requirements aimed at ensuring that they take steps to address the problems outlined in the FTC's complaint. Under that complaint, Drizzly and Relish are required to do a number of things. Firstly, they're required to destroy unnecessary data. Drizzly is required to destroy any personal data it collected that is not necessary for it to provide products or services to its consumers. It must also document and report to the Commission what data it is destroying. It is also required to limit future data collection. So going forward, Drizzly must refrain from collecting or storing personal information unless it is necessary for specific purposes outlined in a retention schedule. It must also publicly detail on its website the information it collects and why such data collection is necessary. The other thing that the order required was to implement an information security program. Drizzly is required to implement a comprehensive information security program and establish security safeguards to protect against the security incidences outlined in the complaint. This includes measures such as providing security training for its employees, designating a high-level employee to oversee the information security program, implementing controls on who can access personal data, and requiring the use of multi-factor authentication to access database and other assets containing consumer data. Notably, the order also applies personally to Relish. Take note, directors and CEOs and CIOs, because Relish presided over Drizzly's data security laxes as CEO. I mean, these days, it's quite common for corporate executives to frequently move from company to company, notwithstanding any blemishes on their track record. So recognizing this reality, the FTC's proposed order will follow Relish, even if he leaves Drizzly. Specifically, RELIS will be required to implement an information security program at future companies, and where he is a majority owner, CEO, or senior officer with information security responsibilities. What I'm going to do also is to have a quick recap on the sanctions imposed by our local laws, taking the data protection laws in Kenya as an example. I know this is a repetition of a little bit of what we did in part 4. So those who attended part 4, please bear me out. We do have a couple of new participants. So for their benefit, I'm very quickly going to go through this. The Kenyan law requires, it imposes both administrative sanctions as well as criminal sanctions. The law provides the Data Protection Office the power to impose administrative fines for failure to comply with the DPA. The fine is 5 million shillings or $50,000, and it is 1% of annual turnover of the preceding financial year, whichever is the lower. But also failure to comply with an order of the office of the DP is considered an offense, and the Section 65 or the DPA accords all data subjects the right to compensation. There's no limit on this right. Criminal sanctions, there are specific offenses under the DPA, including unlawful disclosure of personal data, unlawful disclosure without prior authorization, access to personal data without prior authorization, disclosure to a third party without prior authorization, sale of personal data obtained unlawfully, failure to register as a data processor or controller, provision of false, misleading information during registration, and any obstruction of the Office of Data Commissioner during an investigation. The fines are hefty, 3 million shillings, $30,000, and or imprisonment of a term not exceeding 10 years or both. And in addition, obstruction of the Data Commissioner during an investigation is an offense liable to a fine not exceeding 5 million or imprisonment for a term not exceeding 2 years or to both. At this point, I'm going to hand over to my colleague Chandni for the remainder of the presentations. Chandni, I will continue presenting with the slides. So when you're done, just say next and I'll go to the next slide.
Okay, thank you very much, Zahir. So for this part of the webinar, we are going to see some key questions which are meant for the board of directors. So if the board can positively answer to this question, we can gladly infer that they are indeed very compliant. So next slide so that we can see the questions, please. So here's a list. We've compiled 5 key questions addressed to the board of directors. So as over the past few years, we have witnessed that organizations really struggle to ensure the security and the safeguard of data that they hold. So with regard to this has forced organizations to take some significant decisions with regard to data privacy. So in addition to that, we also have the hefty fines and sanctions under the GDPR and the relevant data protection laws, which has forced organizations to rethink about the importance, the significance of data protection in their organization. So the first and most important question which a board of directors must be able to answer positively is whether that organization has a data privacy culture and whether the organization has the resources to encourage that culture. So usually organization mistakes that the biggest mistake that organization make is that they believe that data protection and privacy is a one-off exercise. they fail to understand that this is a culture that we need to maintain throughout the lifespan of the business. So when we what we mean to when we say encourage and implement data privacy culture. So first of all, an organization must be able to implement a proper data protection framework. That is, its policies, procedures, and other data protection documents. The organization must also allocate proper resources. That is, it must ensure that they have a relevant staff. They must designate a data protection officer as it is mandated by the law. Another resource can be also like materials. Staff must be able to have access to the internet, laptops, computers, data protection website, so that they are able to conduct researches to increase their knowledge in regards to data protection. And most important, an organization must be able to allocate a budget to the data protection. So if an organization has already implemented a data protection framework, it must have a budget to ensure that this framework is being monitored and updated as and when required. In the event that the organization does not have a proper data protection framework in place, the organization must have an action plan to ensure that including data protection is in its way. Like the organization is considering to input that data protection in its function. So for that, the organization must be able to allocate a proper budget for data protection. And also, in order to encourage and maintain that data protection culture in an organization, the board of directors and the management must be able to provide proper data protection training to the employees. Why is training so important? As Zaya mentioned earlier, and I believe you've covered this in other part of a webinar, data subjects have rights, and we have several procedures that all employees of an organization must be familiar with. For example, they must be able to identify a personal access request or a personal data breach. So with regard to this, an organization must be able to provide training to its employees in order that they can identify these areas and address them as soon as the matter arises. So if an organization or the board of directors can answer positively to this question, we can gladly infer that they are indeed very compliant with data protection and they are taking data protection seriously. And then the second question is whether the organization knows what personal data they hold and where that data lives. So as we can say, the board of directors is at the top level in the management hierarchy. So being in that position, a good management who take into consideration data protection must be aware of all processing operation involving personal data in its business. The board must also be aware of the types of personal data that it is processing and the different purposes for which these personal data are being processed. Usually in practice, this is done through a data inventory exercise, where the aim of this exercise is to ensure that the organization is transparent and the organization is taking accountability for the processing of operation, for all processing operation that they are undertaking. So this is knowing what personal data you have, where this personal data is very important, especially where security measures come into play. As we know, we have several categories of personal data. Some of these personal data, which are usually qualified as sensitive data, requires more security measures than the other types of personal data. So the organization must be able to make this distinction between the different types of personal data that they are processing, so that they are able to implement the proper security measures to ensure that data is being protected at all times. So a good management must be able to demonstrate that accountability and transparency to its stakeholders. Like, for example, if we take the case previously discussed, the Drizzy case, we've seen that the company has not disclosed clearly all the personal data that they are processing. In some instances, the organization has processed data more than they should, personal data that they should not be processing. So a good management, a good board of directors must not do this. They should always process data, only the data which are required for the processing operation. Okay. And then the next question that an organization must imperatively answer in a positive way is whether they have a robust security system in place. So we are in a phase where security and data privacy go hand in hand. Like I will take the previous case which we discussed. So why the Drizzly organization got fined and sanctioned? It's mostly because they didn't have the proper security measures in place. So nowadays, everything is online. Internet and online platforms take a major part in our working environment and systems. So every organization must ensure that they have a robust security system in place to protect all these personal data. So IT is always evolving and changing. We cannot stop that. The role of a proper board and a proper organization who takes data protection very seriously must always ensure that they are assessing and re-evaluating their existing security measures. So usually companies believe that once they have implemented some security measures, that's it, the job is done, they don't need to do anything more. But this is not the case. As I said before, IT is always evolving, changing, there are new systems, there are new technologies, everything in place. Security measures as well must be always be reevaluated and changed. So a proper board who take into consideration data protection must always reevaluating and changing its security measures. It must regularly conduct it must conduct risk assessment with regard to its existing security measures to assess whether the system is still effective at the time they are processing personal data. Also, for security, each organization must allocate a budget and an action plan to train staff. Nowadays, we have a lot of professionals, but these people as well require staff to continue to be able to meet the requirement of the ever-changing IT system and laws. So a good organization must be able to have a security measure in a security framework in place that will prevent any breach of personal data or any breach of security, which could lead to any loss of personal data. And then we have a fourth question, which is reporting. So reporting is very important because where we have data protection related matter, we need to know who to address the query to. If an employee has a question, he will address the question to the HR department. But it can be an internal person or an external person. If any data subject has a query, to whom that person is going to address his query. This is why reporting is very important. So a proper board must be able, first of all, designate a person, a specific person, which data protection laws define as a data protection officer in the organization. Every organization which is processing personal data must have a designated data protection officer. So that person is going to address any data protection matters, and he will also be the link between the supervisory authority and the company. So any question that the supervisory authority is going to have, he's going to address it to the data protection officer of that company. So having a data protection officer is very good, but as a company, the company must be able to support that data protection officer in its function. That is, the organization must put all possible resources available to that person. The organization, the board of directors especially, must be able to provide full support to the data protection officer. That is, if ever the data protection officer notices that the company is not that compliant to data protection laws, maybe there has been a change in the law, that person, the DPO, must be able to address that to the board of directors, to the management, and with a full confidence that the board is going to take action. That is, the DPO must have a mandatory support of the management. And then once these little things like support and resources are the things that clearly demonstrate that an organization is indeed complying with data protection and that they are taking data protection seriously. Simple things like just the management support clearly shows that the board of directors is investing in data protection. They are taking this seriously and they are encouraging that data protection culture in their organization. And finally, the last and final question is how the organization demonstrate accountability with regard to data protection compliance. So first of all, when processing personal data, an organization must be fully transparent with regard to the data subject. This is where our data protection documents come into play. Most importantly, the notices. So when you see a company which have privacy notices, they are clearly explicitly defining all the processing operation, the type of processing operation, the types of personal data we are processing. You can easily infer that this company is being transparent to the data subject. And it is certain way it is being also accountable, because in the event, let's say a data breach happened, that company is going to take responsibility and it is going to mitigate that data breach. So accountability is mostly through privacy notices. And I think when we visit several websites, when we see that the website, we have a privacy notice uploaded on that website, we can easily conclude that, okay, this organization is compliant, is data protection compliant, because one of the core principles of data protection is to inform the data subject. So if that organization has a privacy notice on its website, so it is abiding by this principle that it must be transparent to the data subject, and it must inform the data subject of the different processing operation. And then the second way to demonstrate accountability and transparency is by addressing subject access requests. So as we know, and it has been previously discussed in the webinars, data subjects have rights. The GDPR and the different local laws have conferred rights upon the data subject. So they have several rights, and each organization must have a proper procedure in place to address these rights. Failing to do so clearly shows that the organization doesn't care about data protection and doesn't care about the rights of the data subject. So every organization must have a proper procedure in place to address all data subject access requests. As well, it should also provide training to the employees to be able to identify when a person is making a request. So under the law, we have several rights. Once an employee of an organization receives a request, it must immediately be able to understand that, okay, this person is exercising his rights under the data protection law, and that person must know the way forward to address that request, so that to comply with the right, to comply with the laws and not infringe the right of a data subject. And lastly, we have the data protection impact assessment, privacy by design. So these are risk assessment procedures that companies need to undertake. Let's talk about the data protection impact assessment first. So the DPIA for short is a risk assessment procedure. So in data protection, you cannot wait for an incident to happen to address that incident. So organization must conduct risk assessment of its processing operation prior to any incident. So through a DPIA, that organization is assessing whether its processing operation is in line with the data protection laws, and whether that processing operation is not infringing the rights and freedom of a data subject. So this is one way that organization can undertake to ensure that data rights are always protected. And through this kind of assessment, the organization is also reviewing and reassessing their security measures in place. So let's say in a DPIA, the organization notices a few loopholes. The organization has the time to redress that and implement more effective security measures in place to avoid any breaches or any incident relating to personal data. We also have the concept of privacy by design. So this is where organization is going to integrate core principle of data protection in their system at the very beginning itself. So they are not going to wait that incident happen. They are going to do everything at the start itself so that when we are processing personal data, there is no incident at all. So these are a few ways through which an organization can demonstrate accountability. And to conclude with the question, so if an organization or if the board of directors of an organization can positively answer to all these 5 questions, it will mean that the company is very compliant with data protection laws and processing of personal data is done safely in that particular organization. So that's it for a question. Now moving on with so we'll provide you with 5 tips to avoid complaints from regulatory bodies. So as we mentioned earlier, there are hefty fines under the GDPR and even imprisonment sanction. So I don't think any company would want to face that. So here are 5 tips which organizations must bear in mind, especially when they are processing personal data and sensitive data. Next slide, please. Okay. So the first one is data privacy framework and culture in the organization. So the good thing about data protection is that to be compliant, it's mostly about documents. Data protection is all about being transparent to data subject, being accountable. So one way to be transparent and accountable to data subject is through data protection remediation documents. That is policies, procedures, notices, and agreements. So every organization must devise and implement a proper data protection framework in their organization. Also, under some laws, it is mandatory to designate a data protection officer, a DPO. So alongside with the documents, you must also have a designated data protection officer in your organization who will look into all matters related to data protection. Also, in addition to that, another legal requirement, which is the data inventory. So this is an exercise where you are going to a data mapping exercise where you are going to list down all your processing operations, the types of data you're processing, your sources of personal data, your purposes of processing personal data. So through this document, you're demonstrating accountability and transparency, and it is also a legal requirement. So these 3 points under tip 1, once an organization is armed with these so documents, DPO, and data inventory, it is less likely you're going to get any complaint because you're meeting all the legal requirements of the laws. And then we have the next tip is to be proactive and not reactive. That is, what do we mean by be proactive and not reactive? You must not wait for an incident to take place, and then at that time, at that moment, once the incident has already taken place, there is chaos everywhere. Now you're going to design and implement security measures. To be proactive, here we mean that you should be able to anticipate the risk and already have the measures in place to manage or mitigate those risks. So here, by being proactive, we mean that you should be doing regular risk assessment to reevaluate your existing security measures. So how can you be proactive in your organization? Firstly, you can conduct data protection impact assessment of your processing operation. So you're going to conduct DPIAs to assess whether these processing operations are likely to represent a high risk to the rights and freedoms of the data subject. Then you also have a concept of privacy by design, like I explained a bit earlier. So by privacy by design is a means to ensure that all core data protection is implemented in your system right at the beginning. So one way to demonstrate proactiveness is also by providing training to your staff so that they can address any incident relating to the processing of personal data. So here, tip 2 is not to wait for an incident to happen. You should be already equipped. If your organization is processing personal data, from day one of your processing operation, you should be able to have all your security measures in place. You should be able to address any issue with regard to these processing operations. And then tip three is ongoing monitoring. So one of the biggest mistakes we've seen that organizations do is that they believe that data protection is a one-off exercise. So they are going to have all their documents, they are going to do their assessment, risk assessment, all the required tasks, but they are not going to do it on a regular basis. Once it is done, that data protection chapter is closed and put in a drawer. But this is the biggest mistake an organization can do with regard to data protection. Data protection is always evolving, so it's quite new. There's always a new decision, a new find, a new organization which is being sanctioned. So there's always new things with regard to data protection. And since data protection and IT is closely linked, and the IT industry as well is always evolving, it is important to ensure that data protection is ongoing. So you conduct ongoing monitoring. Not once you have all your document, chapter closed and done and dusted, no. So how to achieve ongoing monitoring? The organization can conduct annual compliance audit. So every year, they are going to designate a particular date where they are going to do an audit of their data protection framework. So through this audit, they are going to see what is working, what is no longer effective, what needs to be addressed, what needs to be changed, what new security measures need to be implemented, and so on. Also, another part of ongoing monitoring is the review of data protection remediation documents. So usually we see that organizations, once they have drafted all the documents implemented, there's no change to that document, to these documents, even though that the processing operations are no longer the same. So this is quite a setback for an organization in terms of data protection, because all your documentation must reflect the actual situation of your organization. So having documents which are not up to date, especially privacy notices, this clearly demonstrates that you are no longer being transparent and accountable to your data subject. And as mentioned earlier, lack of transparency, lack of accountability is usually penalized by data protection laws. So every organization must ensure that there is a system of ongoing monitoring in their business. The fourth tip is to be preventive and not remedial. This is closely linked to tip 2. So like we usually say in our day-to-day life, prevention is better than cure. So in data protection as well, we must prevent a situation from happening instead of letting it happen, and then we are going to take adequate measures. So here, every organization must ensure that they have proper and adequate security measures in place with regard to the specific processing operation that they are undertaking. Also, these organizations must regularly reevaluate the effectiveness of their security measures. So one way to achieve that is to conduct regular hypothetical exercises to review and also to assess the knowledge of the staff. So through this type of hypothetical exercises, the organization is going to see whether the measures in place are still effective, whether there need to be changes. They are going to identify loopholes. Because let's say in 2010, an organization has implemented some security measures. In 2022, these security measures can no longer be relevant because there have been so much changes in IT, in system, in technology. So organization must always change, reevaluate the effectiveness of their security measures. They must also have proper procedures in place to address personal data breaches. So it is a fact that breach in security will lead to personal data breaches. And this is something which organization they don't want to face that. Because once an organization has a personal data breach and fails to mitigate or remediate same, like the Drizzy case, they are going to be facing hefty fines. And some company also declare insolvency because they cannot pay those kind of fines. So every organization must have trained staff and a proper procedure in place to address data breaches. And the last tip is registration and renew our certificate. So under the law, it is mandatory that every organization which is processing personal data, that organization must be registered as either a data controller or a data processor. This is the law, it is mandatory. Failure to do so will definitely attract the regulatory bodies and you will face the fines or any other sanction. So also these registration certificate usually comes with expiry date. So every organization must ensure that they renew their certificates as and when required. So this is all for the 5 tips that will help you to avoid the attention of regulatory bodies. So a quick recap will be the first one: you must have all your document procedures in place. You must designate a data protection officer in your organization to look into all data protection related matters. You must conduct regular risk assessment of your system and processing operation. One of the most important one is to ensure that there is an ongoing monitoring throughout the lifespan of your business. That is, you're going to ensure that your company is compliant at all times. Also, you must reassess and reevaluate your security measures from time to time to ensure that they are still effective in the current context. And the last one, you should always be, if you're a company processing personal data, you should be registered with your supervisory authority. And as and when required, you should renew your registration. So this is all for the tips. So now how can we, BDO ITC, help you? So here are a few of our services where we assess company. So first of all is the gap assessment exercise. Through this exercise, we are going to help organizations to identify all their compliance gaps and provide them with recommendations to remediate to these gaps. We also have a data protection remediation and implementation service, which include drafting and implementation of data protection policies, procedures, and contract clauses. We also conduct data protection audit to evaluate the compliance level of organization with regard to data protection laws. That is your either your local law or the GDPR. We also provide data protection officer as a service, what we call outsourced DPO. So through this service, we are going to act as your data protection officer, and we are going to look into all matters related to data protection. We also provide trainings and workshops regularly. So we have our data protection officer training, the data inventory workshop where we help organizations to fill in their data inventory sheet. We also conduct data awareness training where we are going to explain and introduce newcomers to the data protection world and laws and regulation. We also conduct data protection impact assessment workshop where we are going to help organizations to assess, to conduct a risk assessment of their processing operation and ensure that these processing operations are not infringing the rights and freedom of a data subject. And we also provide privacy tools training, that is, with regard to our privacy tools, we help organizations to situate their compliance level. So these are all of our services that we provide here. Next, please.
Thanks, Chandani. And that brings us to the conclusion of our webinar for today. I do apologize for the overrun, but I think you'll probably agree with me that today's topics were very, very pertinent. We were building up our 5-part series, to the most important issues. And I think hopefully you'll agree that we've unbundled those issues for you. These are the contacts at BDO, myself, my phone number, as well as my email address. I can basically take any inquiry from any of the East African countries, including Ethiopia, and my colleague, Sylvie Gregor in Mauritius. Again, those are her contacts, her phone number and her email address. So basically, we can cover all of the East African region between the two of us. That really brings us to the end. I'd like to thank all of you for the time you've taken and for your participation. And if there are any questions, we'll take them now. Otherwise, we can draw this webinar to a conclusion. Over to you, Paul.
Thank you, Zahir. I'd go back to some of the questions. We have managed to answer most of the questions on the Q&A box, myself and Rushda. However, I just want to take 2 questions. One that came from RISPA also, where the question was, are there any landmark cases currently in Kenya? And we have responded to that already. Maybe Zahir, you can also chip in on that.
I think the registration requirement in Kenya commenced in July of this year. And therefore, at the moment, the commissioner is being quite lenient because people are finding their way to implementing the law. But you can expect action. I think you saw the notice on 40 digital providers by the commissioner because of various complaints. So the commissioner is taking complaints, and definitely we're going to see cases in the Kenyan space, but in the very near future. But at the moment, I think we don't actually have any matters that have gone to court.
All right. One more question. Are employees liable for data breach? A specific employee, is that employee liable for the breach, or is it the employer?
Right. So this is a very good question. In one of my previous webinars, I gave an example of a case where the CIO was held personally liable. And the reason he was held personally liable was because the judge, the whole bench, unanimously agreed that he had withheld information. There was an ongoing investigation. The company had been put on notice, okay, about data breaches and to remedy those. And those notices, and there was basically a deliberate attempt to cover up. So once an organization is on the radar of the commissioner, you know, you really have to cooperate. You've got to be completely transparent. You've got to do exactly what they're saying. If you try and cover up your tracks and you think that you may get away with it, those can have very serious consequences. So yes, to answer your question, both the organization as well as the individual that's responsible for the implementation of the data protection program can and will be held liable.
Thank you, Zahir. We have answered most of the other questions, and in the interest of time, I would like to end this webinar series and thank all those who have participated. Just a point to note that your certificates of attendance will be issued once we close this webinar. Again, this session was recorded and is available on YouTube for future reference. And to sign off, I give it back to Zahir just to give the vote of thanks. Thank you all.
Thanks, Paul. And yeah, thank you so much to all the participants who've been with us. We hope that you found these webinars useful. If you have, please drop your comments. You've got my email address. We'd be very happy to come back to you on any issues that you have. Otherwise, you know, I wish you well. You have a free December, no webinars then, but we will be back in January and we will notify you when we're back. And I look forward to seeing you in the very near future. Thank you and bye-bye.
Yves, tu peux présenter.